In this video, we are reviewing the DUI arrest of an off-duty state trooper after he was involved in a rear-end collision. This is a special circumstance because while we've seen plenty of police officers arrested for DUI, this is the first time I've ever found an experienced DUI cop being investigated and then arrested for DUI himself. We're going to watch the body camera footage, we're going to review the police report, and we're going to discuss how the state trooper's handling of being investigated for DUI ultimately resulted in his case being dismissed. We'll start by saying I know this state trooper personally. We served together on FHP Orlando's DUI squad from 2006 to 2009. In 2009, I resigned from the Florida Highway Patrol and he continued his career as a state trooper. I have personal knowledge that this state trooper has conducted thousands of DUI investigations and made over 100 DUI arrests. This is not the norm. Most police officers go through their entire career making fewer than 2 DUI arrests. I'll use stats from 2025 to prove my point. According to my records, year-to-date 2025, which includes January and February, 864 officers have made at least one arrest of any kind. Only 199 officers have made more than 5 arrests. Let's compare those previous numbers to the DUI arrests in the same time frame. So far in 2025, only 96 officers have made at least one DUI arrest, and only 2 officers have made more than 5 DUI arrests. Many police officers will not make a DUI arrest even if it falls into their lap. Now, there's many reasons for this, and that's outside the scope of this video. What's important to note is that the nuances of DUI are often overlooked by experienced police officers, and that's what ultimately resulted in this case being dismissed. Let's take a look at this body camera video. Using Adobe editing software, I'm able to upload all the body camera video files to make a better viewing experience. In this particular circumstance, I've highlighted the arresting officer's video in pink and the crash investigation officer's video in green. Notice the gaps? Why are these police officers turning their body cameras off? That's another question. Let's watch the video.
You don't understand why you're at fault?
No.
Because you rear-ended a vehicle in traffic? No what?
I have no idea how I ended up at fault of the crash.
I'm sorry?
I have no idea how I ended up at fault of the crash.
Well, I'm telling you, you rear-ended a vehicle in traffic.
How?
How? You drove your truck into the back of theirs. That's how. Okay. You were at fault for the crash. Here's your license back. That concludes my portion of the investigation. Okay?
Okay.
You're going to have to speak with another officer in a moment. You understand?
Go ahead and give me that. You're not free, Bill.
Yes, sir.
Okay, how you doing? I'm Officer Baker with the Orlando Police Department. I'm sure the other officer explained to you the civil portion of this crash, so he's talked to you about your accident. I'm going to be conducting a different investigation, okay? We're going to be conducting a criminal investigation now, based upon...
I refuse everything.
You're refusing?
Yes.
Okay. Send it.
I'm not doing anything wrong. I'm not trying to refuse anything.
You just said you refuse everything.
I'm going to be thanking you guys.
What team is that?
FHP.
FHP?
Yes.
What do you do for FHP?
I'm a trooper.
In order to detain someone, such as on a traffic stop, a police officer must have reasonable articulable suspicion of criminal activity or a traffic infraction. If the officer wishes to conduct a DUI investigation, the officer has to have additional reasonable articulable suspicion above and beyond the original grounds to believe that the person is impaired. In order to go through with the actual arrest, the officer has to have probable cause to believe the person was driving while under the influence. After the arrest and bonding out of jail, the state trooper hired one of the top DUI defense attorneys in the state of Florida. That defense attorney filed a motion to suppress. He asked the judge to exclude all the negative evidence gathered against the state trooper. That's where we get to the dismissal of the case. This DUI arrest involved a traffic accident as well as the refusal to perform roadside sobriety exercises. These two circumstances add layers of complexity to the DUI investigation that the officer did not take into account. In Florida, statements made to police officers during the course of a crash investigation are inadmissible. They're protected as if the officer had to read you your Miranda rights. So no matter what the state trooper admitted to the officer about drinking, about driving, or about being impaired, none of that will be heard by the judge. And the judge has to make a determination whether the officers had reasonable articulable suspicion to conduct a DUI investigation, and further, whether they had probable cause to make a DUI arrest. In order to detain someone, a police officer has to have reasonable articulable suspicion to believe that criminal activity or violation of law did occur, will occur, or is occurring. And in order to arrest someone or issue the citation, that level raises to probable cause. Probable cause is a fluid concept based upon the assessment of probabilities in particular factual contexts, not readily or even usefully reduced to a neat set of legal rules. When I teach this section at the police academy, I break this down into degrees of certainty. There's 4 legal standards that the officers must be very familiar with: mere suspicion, reasonable articulable suspicion, probable cause, and proof beyond a reasonable doubt. These are graduating in nature and allow the officer additional powers to detain someone or take them to jail. When a subject refuses to do roadside sobriety exercises, like the state trooper did here, the officer cannot use that refusal against the person unless the officer provides the suspect with an adverse consequence. Once the suspect is made aware that the refusal to perform roadside sobriety exercises can be used against them, at that point in time, the officer can use the person's refusal as an indicator of impairment. Everything we heard in that video before the officer switched hats cannot be used against the trooper. And when the trooper refused to do the roadside sobriety exercises, the officer went immediately to arrest. So the evidence that officers have against the trooper is relatively limited. The defense attorneys scheduled an evidentiary hearing to explain to the judge why she should exclude the evidence to be used against the state trooper. Both officers testified at this hearing. Now, I have not heard this hearing testimony myself, but I have reviewed the prosecutor's notes. It appears as though the officers did not present well and may have come off as less than credible. At the end of the hearing, the judge ruled that the officers did not have the reasonable articulable suspicion to extend the crash investigation into a DUI and did not have the probable cause required to make a DUI arrest. Because of this ruling, the evidence at the point in time the officer switches hats, all of that is excluded, meaning the state attorney's office doesn't have a case and they were forced to drop the charges. I've pulled up the arresting officer's arrest statistics for the past several months. It doesn't appear that he makes many DUI arrests at all and is likely inexperienced in conducting complex DUI investigations like you have in this scenario. Even though the judge ruled the detention was unlawful and therefore excluded all the evidence, resulting in the case being dropped, the driver's license office upheld the suspension for refusal to submit to the breath test. The trooper has to live with a hardship license for the next 12 months. It's also my understanding that the Florida Highway Patrol terminated his employment after 21 years.